Let's go ahead and get the slides up. Hopefully that's working correctly. And so welcome to the Community Association collection class. Should I pay or should I go? I'm not going to sing and ruin everyone's day, but we'll just go ahead and move on. As Jeff mentioned, my name is Alan Schwartzseid. I'm the managing partner of Kaye Rembaum's Orlando office. We do have offices in Pompano, Palm Beach, Tampa, and in Miami by appointment only, in addition to the office that I manage here in Orlando, right next to UCF. We've got 20 attorneys. All we practice is community association law. So we're only really representing condos, HOAs, and co-ops and dealing with issues pertaining to those types of community associations. 8 of our attorneys are board certified in these areas of law. The bottom line, this is what we've done since the 90s. I say we as a firm, not me personally, because I was in high school at that time, but moving along.
I take exception to that, by the way, but go ahead. That's okay.
That's fair. We've got 8 attorneys board certified in this area of law. This is all we do. If your community has any issues, whether it's collection related or otherwise, this is all we do all day long. We'd be happy to hear from you. My email address is right here on this first slide that hopefully you're seeing on the screen right now, as@kbrlegal.com. I truly welcome anyone. Thank you, Jeff. I truly welcome anyone that is, has any questions about community association law in general. Feel free to reach out. Now, you're going to have the Q&A towards the end of this class regarding collection in particular, but if your question is about something else, or frankly, you just don't have counsel that you're happy with right now, we'd be happy to hear from you. Feel free to reach out to me directly. We do practice statewide, as I mentioned, but let's just go ahead and rather than me rambling on about our firm and me, let's get into the meat and potatoes. So if I can, there we go. Okay, so how and why are we actually able to take someone's property away from them? And when I say property, I mean real property. I don't mean just, well, we can take their car, we can take their iPad to pay for some kind of judgment. I'm talking about the association can actually lien and foreclose for unpaid assessments and maybe some other charges that we'll get into later. Essentially, the declaration, whether that's a declaration of condominium, a declaration of covenants, conditions, and restrictions, which a lot of people refer to as your CC&Rs, or if you're in a co-op, that would generally be your master form proprietary lease. All of that is going to say that the association has a lien for all unpaid assessments and certain related charges. Now, that lien is also going to include the unpaid interest, late fees, attorney's fees, and costs incurred in collection, and other charges. That could be fines if you're in an HOA. It's not allowed in a condo or co-op to be liened for. So you can have fines, you just can't lien for them in anything other than an HOA. The legislature is trying pretty much every year to make it so that HOAs either can't lien for those either, or can't lien unless the dollar figure is a certain amount. So just beware that even if you're able to do that now, I don't necessarily recommend it, and it might not be something you can do at all in the near future. The budget for the association determines the maintenance assessment amounts. You use the procedure that the bylaws say, or what the Florida statutes or Florida administrative code require. But this is where you're going to get your assessment amounts. Now, you can have special assessments, which are anything not included in the budget and generally will apply to the entire community. Or you might have what we call an individual assessment or a benefited assessment. This is basically something where the association went onto someone's property, took care of a violation, and they charge that as an assessment. One thing that you probably don't have that I will suggest every board in Florida consider is a provision in your governing documents. Could be through an amendment if you don't already have it, but it would generally be a provision in the declaration where it talks about attorney's fees and costs incurred in covenant enforcement. I suggest you make that an assessment against the lot that caused the violation. The reason for that is that rather than that being a cost of doing business, you're now making this another assessment that gets collected in the same manner as your maintenance assessments. So we'll talk about how that works going forward, but the bottom line is you're just creating one more thing that you are allowed to lien and foreclose for so that you have a real remedy when the owners inevitably fail to pay those attorney's fees and costs back to the association. So a lot of firms look at that as a cost of doing business. You're doing covenant enforcement, whatever dollars you spend in doing that, you're not going to get it back. I don't like looking at anything that way unless the Florida statutes say you can't recover it that way. And even then, we get a little creative. So moving forward, if you're going to levy a special assessment, you're going to have to give 14 days notice at a minimum that the assessment's going to be considered. The purpose for that special assessment, again, these are anything other than your budget, basically. The estimated cost and when it's going to be due should also potentially be included. That notice is going to be posted conspicuously on the association property and mailed or hand delivered to the members. It can be electronically served if that particular member has agreed to accept service of association notices via email. The other thing that we recommend doing when you're adopting those individual assessments, give that same 14-day notice, but only to the lot or lots that are actually being assessed with this. So this is the boring stuff. Let's move on. Once you have the assessment, the invoices need to be delivered to the owner. Basically, you have to tell someone they owe the money before they owe the money. Now, when I get the argument, here's where we're not just talking about the basics, okay? When I get the argument from someone that the association had an obligation to tell them what the assessment amount is so they don't have to pay anything because they didn't get the notice, sorry, it doesn't work that way. So when your owners say, well, I didn't get the invoice, the association doesn't necessarily need to send a specific form of invoice. All you need to send is whatever form you've been sending in the past. And if nothing is sent, then basically my argument, whether it flies in court or not, is that you just roll over from the last budget. Or you have a new budget and it's the member's responsibility to find out what they owe. The obligation to pay doesn't disappear just because you didn't get an invoice from your automotive lender this month, right? You still have to pay that or they repossess the car. Same thing works with your property and association assessments. You don't not owe the mortgage installment because the lender didn't send you a new invoice this month. You have an obligation to know what that amount is and to make sure it's paid. So that argument, oh, well, we didn't get any kind of notice. Yeah, I doubt that. You probably got a notice that there was going to be a meeting. You got a notice that there was a meeting that was held and that the budget was adopted. You may not have gotten a specific invoice. That doesn't alleviate your responsibility for all those payments. Now, if you're going to change the way you send those invoices, Florida statutes were changed a couple of years ago to basically say that the owner needs to actually accept the new method of sending invoices. What we're talking about here is you used to send a coupon book, now you're sending an email. Or you used to send, I don't know, something else. But basically, anytime that's changed, that method of delivering the invoice has changed, whether that's from a coupon book to an email or an email to something else, some other method of notification, something that goes on the website instead, you need to let those owners know at least 30 days before you make the change, and they need to actually agree to the change. Now, once you send that notice out, it's considered, okay, well, we notified you, you owe these assessments. That's all you got to do. You're not obligated as an association to make sure every single owner gets that notification. It's their responsibility to collect their mail. Okay, and it's all you have to do is prove that you sent it out. That's it. Okay, moving forward. What's a delinquency? This is another mistake that I see people making. Okay, the fact that someone didn't pay on time does not mean their account is delinquent. Sorry, let me step back here. If I can. There we go. That doesn't mean that the account's delinquent. What that means is that they didn't pay on time. Your declaration or your bylaws are going to specify what a delinquency is. Okay, it's basically going to say, well, if you don't pay within 15 days, then interest accrues, blah, blah, blah. That doesn't mean that on day one, you start accruing interest. If it says after 30 days that it's not paid, late fees accrue. You're not accruing late fees on day one. You're accruing late fees on day 31. So just understand the period of delinquency isn't set in the statute. It's not automatically the day after the payment was due. It's what your declaration says. This is why one of the policies that I think every community association should have is a policy governing how you're going to handle collection. We're going to go through these steps that Alan's describing today. And one of those steps is determining or having your attorney determine and put in the policy that they're drafting for you, when is an assessment delinquent? because that's a really crucial time frame when it comes to when you're able to send out notices of delinquency and things of that nature. Now, interest and late fees. I want you to understand the association has a statutory right to collect interest on late paid assessments. You might have a time frame where you got to wait, which is the delinquency period we just talked about, but you have an automatic right to collect interest. Unless your governing documents say that it's less, you can collect 18% interest per year. That is also, however, the statutory maximum, meaning if your governing documents say you get 50% interest, sorry, but you can only collect 18. Now, late fees are a different story, and that's because the statute specifies, and this is statutory for all three types of community associations, condo, HOA, co-op. You only get your late fees if your governing documents say so. If your declaration or bylaws specify that you're authorized to collect late fees. They may have a specific dollar figure. Again, we're looking at a specific dollar figure in the statute if it's silent as to what the amount is. The most you can collect is the greater of $25 or 5% of each delinquent installment for late fees. Where I see people screw this one up is where they're charging $25 per month, but it's a quarterly assessment. That's $100. Well, that would be more than 5%. You'd be charging the 25 per installment, but now you're charging it 3 times per installment because your assessments are quarterly and you're charging this every month. So make sure, and some management firm softwares do this automatically, and it's unfortunately not correct under Florida law or under your governing documents. You want to make sure that you're charging 1 late fee per installment. If you want to break that late fee up, let's say you've got a $1,500 installment, it's annual, and you want it to be 5% spread amongst the entire year, that's okay. Don't charge it until the account's delinquent, but you can spread it up, but only spread up the 5% total on that installment. Hopefully I'm clear on that. Attorney's fees and costs that you incur in collection are not like pretty much anything else in Florida. When you incur attorney's fees and costs, demanding payment of an unpaid HOA, condo, or co-op assessment, those are automatically recoverable, regardless of whether you file a lawsuit or not under Florida law. On most other things, the only way you have the right to recover those fees and costs, if you haven't filed a lawsuit, and in most cases, you haven't won that lawsuit already, is if you have an amendment like the one that I described earlier regarding covenant enforcement. So just understand, here, you have an automatic right to recover fees and costs, unless you screwed something up. Hopefully you did. Owners that claim, oh, no, I paid in full, but you've got interest, late fees, attorney's fees, and costs that have accrued, they're wrong, period. Sorry, that's absolutely wrong. You've paid the amount of assessments that accrued. You have not paid the balance in full. So once that account goes delinquent, what you want to do is make sure that your attorney and your internal policies, or whatever you're doing if you don't have internal policies, are going to lead to either obtaining payment, advancing the collection matter to the next step, or preferably both. Okay, you don't want to do something that you don't have an obligation to do, or that doesn't benefit the association by getting you closer to foreclosing or collecting that money. Anything that doesn't get you closer to one of those two, from my perspective, is wasted time and wasted attorney's fees if your attorney's the one doing it. You want to have an aggressive collection policy in place. That makes the association more likely to be able to negotiate from a stronger stance. You're already in a strong stance because in reality, there's really no defense to a foreclosure action for unpaid assessments other than a problem with the budgeting process or something else that went wrong in the collection process. Okay, it's not, well, you know, John told me I could pay next week and I didn't pay next week, so I still shouldn't be foreclosed. No, a lot of those types of defenses are raised, but they're invalid under Florida law. Florida law is very clear. The only defense to a foreclosure action by an association pertains to the process of levying the assessments or something that happened after that assessment was levied that directly impacts the assessment. So there's case law that says, well, you know, we shouldn't have levied the assessment. No, you don't not pay it. You challenge the validity of the assessment after you've paid it. You don't just ignore the obligation. Okay, so failing to maintain the common elements, common areas, None of that has anything to do with the obligation to pay assessments. Failure to accept partial payments, that is a defense. But again, you want to have a written policy that says what notices are issued before the account is automatically submitted to counsel, what's acceptable for settling, and whether you're willing to waive any interest or late fees. You don't necessarily want to give away all of that information, but these are things to consider in any internal policy that you might adopt. Settlement, it's always tease, tease, tease. Well, I want to settle, but I don't have the money. Okay, that's great. We'll enter a written agreement that says you're going to pay X amount per month in exchange for us holding off on this process. But also, you need to do something in exchange for us agreeing to hold off. Okay. It's not just, well, we'll wait until you can afford to pay it. It's we're going to give you more time in exchange for you as the owner waiving your right to certain notices, waiving your right to direct service a process in hand. Basically, what we're going to do is streamline our foreclosure remedy that we would have been proceeding with but for this written agreement. Okay, we're basically saying we can give you time. You want 6 months, you want a year. It's up to the board how long to give or whether to give a payment plan at all. My recommendation is do it, but understanding that the reason for doing it is not necessarily just to benefit your community. It's not to help the owners. Because let's be realistic. What we're talking about is owners putting the entire membership in a position where everyone else is covering their butts because this money was needed and was budgeted for to properly maintain and operate your community. So again, we're putting them in a position where in writing, not verbally, which creates a he said, she said situation, the owner is agreeing, I'm going to pay all the attorney's fees and costs incurred by the association in collection and in preparing the agreement. I'm going to go ahead and make sure that everything gets paid off within the next 6 months. And if I don't do what I say I'm going to do, then the association has the ability to skip all the notices Alan's talking about today, to skip everything else they're required to do, and to immediately file a lien against the property and go after the owner in foreclosure. Oh, and the owner is also going to agree to accept service of process in that foreclosure lawsuit, either via mail, or via email, meaning that you don't have to go out and chase them to actually locate the owner who could otherwise spend a bunch of time wasting your time evading service to delay the inevitable foreclosure. Moving forward, common issues that we see in the collection process. And just by way of background, I wrote the book on collection for condos and assisted with writing the book for HOAs. Those are both pending publication. Actually, I flipped those around. I wrote it for HOA, helped for condo. And this is all I did for 8 years. Started in 2010 with the firm and then moved on to, instead of doing this work in 2018, I started managing a department that did this collection work. So hopefully by now I know what I'm talking about. But these are the problems that I've seen in the past 14 years, I think. Inaccurate accounting. So the association accepts payments, doesn't tell the law firm we have no idea that there was a payment made, or they provide a ledger or they settle with an owner after the account was submitted for collection. Unpaid taxes. Tax deed sales will eliminate your entire obligation, meaning that the association's not owed anything except from the owner, meaning the property is not encumbered by that dollar figure that was owed for assessments once that tax deed sale goes through. Now, just like a first mortgage foreclosing, a tax deed sale is something where the association can seek surplus funds, meaning the taxes were 10 grand, the property sold for 100. There's 90 left for all of the lien holders who were wiped out via the tax deed sale to try and recover what they're owed. The problem with trying to do it that way is that a first mortgage is almost always going to get that money before the association does. That doesn't mean you shouldn't file a claim and try and get the money. If the lender screws up, great. But it does mean that, you might be eliminated. Mortgage foreclosure and bankruptcy can really slow us down. Mortgage foreclosure, it's generally up to the board whether to proceed and risk that all those attorney's fees and costs you're spending are going to be wiped out by the lender. In bankruptcy, we don't have that choice. We have to stop everything due to the automatic stay that's imposed by the filing of that bankruptcy petition. Judges' decisions sometimes are just bad based on what they consider fair, because these are cases of equity. They're supposed to be following the law and the case law and legal decisions, but just understand judges don't always do that. I respect a lot of judges. Matter of fact, I'm a part of a group that meets with attorneys and judges in Seminole County, up in the Orlando area, once a month. And we have a great time. I think that some of the judges in these areas in Orange and Seminole are some of the best I've experienced. But just understand, a judge is basically an attorney that was elected to a position. So it doesn't mean that they have knowledge in any particular area of law. So we spend a lot of time educating judges, and sometimes that education doesn't take. Judges determine what a reasonable attorney's fee is. You can spend $5,000 on a foreclosure that was contested. That doesn't mean that the judge is going to award it all to you. So you might not recover all of your fees and costs, even though you're entitled to them. There are things that you can do as, I like to say, alternatives. I would prefer that they be supplements to the collection process. You can send a rent demand notice. If you know that that property is rented out, you don't have to be in the collection process to send a demand to the tenant. Under Florida law, in a condo or HOA, sorry, co-ops, I don't think that's included in 719. But you send that notice that basically says, hey, you're obligated to pay us all of your rent until your landlord is paid in full with the association. You're not going to give amounts. You're not going to say what's owed. You're just going to say you need to pay us, and then you don't need to pay us anymore when it's paid in full. There is a provision in both of these statutes, just understand, that specifically says the landlord cannot evict you for non-payment if you're paying us instead. So that is something that's not in the statutory notice, but I copy and paste that right into the letter so that the tenant understands that they're not going to get booted out of the property by paying the association instead of their lender. You might have the right to suspend voting rights. You do have the right to suspend the right to use certain common areas, common elements. There's limitations to that. I suggest checking out our covenant enforcement class if that's something you're interested in using. But it's basically saying you can't go to the gym, you can't go to the pool until you pay us in full. That's really just going to require a board meeting and a notice to the owner. You can advance or cause the lender's action to get dismissed, or you can collect from the surplus resulting from their foreclosure sale. Schedule or attend hearings in the lender's case management conferences to try and get the case moving. There's a bunch of motions that the association can file to get the case moving or dismissed. You can seek funds made available via tax deed sale. So these are just things that you can consider. And I know I'm blitzing through some of this, but we're 25 minutes in and I'm on slide 8 of 38. But you'll get these materials, as Jeff mentioned, once we're done with the class. So let's start talking about the pre-suit phase. Now you've decided, okay, the account's delinquent, the owner hasn't paid, they owe us a bunch of money. Hopefully we've got a policy in place that says we're automatically going to move this forward. The board doesn't even need to vote on it. The manager just moves it forward. If you don't have a manager, you still should have in there that the board doesn't need to meet. You just say, here are the accounts that are delinquent. We're moving forward with them. The first thing you need to do is send what's called a notice of late assessment. This is something that was added to the statute a couple of years ago because a legislator's mother received a notice that said, you owe us X amount of dollars in attorney's fees and costs. And it was the first time she was informed that this account was delinquent. So now we've got a requirement to send this courtesy notice, which really is a courtesy because you can't charge any attorney's fees and costs for sending it out. You can't, it's good for 30 days. It just goes via regular mail. And it basically is, here's a breakdown of the balance that you owe the association. If you don't pay us within 30 days, we're going to move forward in this process. Okay, so this is a very straightforward, and we've got all the specifics of these notices in here. I'm not going to go through them all, but I will explain what each notice basically says. So again, that's a 30-day notice. That's it. It just says you owe us some money. We're not charging attorney's fees and costs. And if you don't pay within the 30 days, we're moving forward with the collection process. My recommendation and that of the firm is that the association's manager, accountant, whoever's working on this within the association should send this notice out, primarily because you can't charge attorney's fees and costs incurred in sending it out. So as a result, rather than pay, a couple $100 every time that you need one of these sent out because an owner's delinquent, my recommendation is have a form prepared by your attorney. That will be maybe an hour or two of attorney's fees, but then you can use that form unless and until the statutory form is changed. The next notice that goes out after that notice expires, that notice of late assessment was sent, it expires. The other thing, I'm sorry, let me step back. Make sure that you have an affidavit confirming that that notice was sent out. There's a provision in the statute that says that basically an owner has no basis to challenge whether that notice was sent if there's an affidavit in the association's official records saying that it was sent out. Now, there's a little bit of discrepancy for all three of the notices that need to be sent before you file a lawsuit as to whether it's deemed completed upon mailing or when the owner receives it. My opinion is, and I've never seen a judge say otherwise, all you're required to do is send it out. The reason for this is, logically speaking, I can't guarantee that an owner receives a notice, and there's absolutely no reason, and the Florida statutes don't state, in my opinion, that we should be held up and basically precluded from ever using this remedy of foreclosure because an owner chose not to collect their mail and they never received the document. So just understand, this is something that basically you just need to send it out and we move forward as the timeframes expire. So the next notice after the notice of late assessment expires is a notice of intent to file a claim of lien. It basically is what it says. It's a 45-day notice sent in a specific manner, breaking down the balance due and saying, if you don't pay this balance within these 45 days, just understand we're going to file a lien against your property. Now understand, look at the statute numbers here. 719 is not included. If you're in a co-op, this is not technically required. I still recommend you send it out because most judges don't seem to understand that there are even a separate set of statutes for co-ops in Florida because there are so few of them that end up in litigation. So I would recommend you do it even though you don't have to. It's just another 45 days. You're then going to record your claim of lien if that 45-day notice of intent expires. Your lien's basically going to say, well, we're securing all of our interest in the assessments, interest, late fees, attorney's fees, and costs that are due on this account right now and going forward through the completion of any foreclosure action we file based on this lien. It's not going to include post-recording special assessments. There's case law that basically says those special assessments are separate and distinct unless they're in the lien itself. Okay, the lien statutorily relates back to the date of recording the declaration, meaning you basically have a lien from the date the declaration is recorded going forward. This is going to give you, I was going to say superiority and priority, but I mixed the two words together. Sorry. It's going to give you that superiority over almost any other lien, unless your declaration says otherwise. Almost every declaration in Florida, almost every proprietary lease in Florida is going to say that a first mortgage is still superior to this lien of the association. Some will say that it's only effective as your lien as of the date that a physical claim of lien is recorded in the county records. So your attorney should be giving you guidance on that if you want to know what priority your lien has over other liens against the property. You are subordinate to ad valorem taxes, which is why that tax deed sale can wipe us out. Now, once that lien's been sent for recording, or from some people's perspective, it's recorded, it's good for 1 year in a condo or a co-op. That's statutory. HOAs don't have a statutory time frame, but there is a statute of limitations of 5 years to collect the assessment. Now, when that 5 years begins, I don't think any attorney knows for 100% certain how a judge is going to rule on that. It could be the date the assessment actually accrued. It could be the date the first letter was sent, the notice of late assessment, the date the intent to lien was sent, the date the lien was recorded, the date the notice of intent to foreclose was recorded. 5 years from any of these dates is what I've seen judges ruling on. So just understand you are taking a risk by waiting around. My recommendation is get this collection moving immediately and automatically so you never have to deal with that 1 year or 5 year time frame. The only time you should ever have to deal with that and ever have that much in assessments past due without having filed a lawsuit is if the owner filed a bankruptcy petition and it held you up because of the automatic stay. Now, the final pre-suit notice is pretty much the same as the intent to lien, but the intent that you're stating in the letter is to foreclose the lien. So you've already got your claim of lien. It's been recorded or it's sent for recording, depending on your attorney. We're going to move forward and actually tell you that in 45 days, we're going to file a foreclosure action if you don't pay. Some people will take this as, well, they're taking my house if I don't pay within 45 days, and that can't happen. You're right, it can't. We still need to file our lawsuit and proceed. Okay, so just understand this is not the notice of intent to actually get a foreclosure sale within 45 days. It's notice of intent to file the foreclosure action lawsuit within 45 days. It's basically going to update the amounts. Owners can require that an association file the foreclosure lawsuit sooner, within 90 days, or basically start over if you don't file within that 90 days by filing what's called a notice of contest of lien. I've seen this happen 3 times in my career. It's very rare, but it is something that the association can be subjected to. Basically, the owner saying, come and get me. You want to file? Go ahead. Have at it. Even if the intent to foreclose or notice of contest of lien hasn't expired, and a condo association can file suit upon recording a lien, but just understand you're risking your attorney's fees and costs being eliminated if the owner pays all of the assessments before a judgment is entered. What this means is, don't do it. Go forward, have your notice of intent to file a foreclosure action be sent and expire. All this is saying is that you are technically allowed to risk your attorney's fees and costs by filing too early, but you can still file the lawsuit. This is something that I mentioned because a lot of even attorneys aren't aware of it. They think that you have to allow the notice of intent to foreclose to expire. It's recommended in the statute and by me, but it's not absolutely required. So now we get to the actual lawsuit. Your notices have all been sent. They've all expired. The owner has paid less than the full balance. Notice what I just said. I didn't say they haven't paid anything. I said they haven't resolved the balance due. Okay? You're still able to file your lawsuit. As long as the owner hasn't paid in full at any time during this procedure, you keep moving. And I don't think we've mentioned it. It might be later in the slides, but I want to be clear on something. When an owner makes a payment, that payment gets applied in a specific statutorily prescribed order. You're going to apply it first to interest, then to late fees, then costs and attorney's fees incurred in collection, then to the assessment. What this means is, like I said earlier, if an owner claims, oh, I paid in full and it was only the assessment amount, sorry, but that's not payment in full. We've incurred other charges that you now have a legal obligation to pay before this account gets closed out. Okay, so we can go through the initial filing documents, but the complaint's basically the lawsuit. The exhibits to the complaint are going to be your governing documents, and whatever documentation is going to show that you have a right to foreclose and a right to damages, because this is also a breach of contract claim that you can bring. I generally have brought them both together unless for some reason you can't bring the damages claim. All that's doing is giving you other collection avenues once you get your judgment. Some attorneys will only go for foreclosure. I don't necessarily agree with that. I want to make sure that everything we can get is included. A lease pendens is another document that's filed at the same time. It basically says, hey, there's a lawsuit that's been filed against this property, and it gets recorded in the county public records, just like your declaration, just like everyone's deed, to let everyone know. And when I say everyone, I don't just mean your community. I mean anyone that might have an interest in buying this property, lending on this property, owning this property, etc. They're considered on notice. It's called constructive notice by recording that this lawsuit is pending in court. And then a summons is basically a document that the clerk will issue that gets served along with the lawsuit and tells the owner you've got 20 days to respond to the lawsuit or you can be defaulted. The defendants that are named in this case, usually you're going to talk about the owners being named, anyone with a potential interest due to a bad deed or something that hasn't kicked in yet, meaning a remainder interest, a known trust beneficiary, etc. What we're doing by naming these individuals, these entities, is wiping out their interest in the property. We're not saying you owe us the money. We're saying we want to get rid of your interest in the property, whether that's a lien, or here we talk about second mortgages and other junior lien holders, depending what's in your declaration, whether you can do that or not. But here we talk about the owner's spouse, so you're foreclosing their homestead rights, which they would otherwise keep, and any occupants to foreclose tenancy rights that they might otherwise keep. So we're just wiping out every interest that we can by naming them as defendants in the lawsuit. It doesn't mean we're claiming they owe money to the association just by naming them in the lawsuit. Now understand, a first mortgage can't be foreclosed unless the lender really screwed up. And by really screwed up, I mean the declaration says that the lien relates back to the recording of the declaration and doesn't contain a clause that says that the lender is superior in lien rights, or the declaration has no lien subordination clause whatsoever. So basically, you're superior to anything other than taxes. And keep in mind also, anyone that's not named in that lawsuit keeps their interest in the property. If you name the lender improperly, this is why I want to clarify. A lot of people ask why we're not suing the lender and letting them know so that they can pay off the association. You can actually end up responsible for the lender's attorney's fees and costs incurred in getting them dismissed from a case where they were improperly included if you name them. So if you want to risk that 10, 20 grand that they're going to probably trump up and say, well, you know, we spent a lot of time on this. We had to go to a motion calendar hearings and significant hearings to show that we have a superior interest in the property, blah, blah, blah. Avoid that. We can't name a superior lien holder. A first mortgage is almost always going to be superior to the association, and that's why we're not naming them. We're not putting them on notice because, frankly, they don't care what happens with our foreclosure other than the fact that we might be moving that owner out of the property who then has no reason to pay the mortgage. Okay, but we're not going to name them. We're not going to send them copies of the lawsuit. It's just not necessary. If no one responds to the lawsuit, then generally we can have a default entered against the defendants that didn't respond after they were served. That default admits all well-pled allegations of the complaint. What that means for practical purposes in plain English is they've admitted that their interest in the property is superior to that of the association. If it's the owners, they're admitting that they owe the money for the most part. What they're not admitting to is the dollar figure that they owe, which the association still has an obligation to prove. A motion to dismiss might also be filed. It's basically, well, on the four corners of the complaint and the exhibits, this doesn't state a claim. They can't foreclose, period. Not we have a defense to this, but, well, the association didn't do enough in its pleading to have the court justify considering whether to enter a judgment in favor of the association. An answer is going to admit, deny, or state a lack of knowledge as to each allegation of the complaint. It might say affirmative defenses, raise counterclaims, cross-claims, third-party claims, basically saying, well, yes, but you did this, association. You were wrong here, and so I should be entitled to sue you too. That's what a counterclaim is. A lot of times, owners that don't have the money to pay their assessments also don't have the money to hire an attorney. You'd be surprised at how many of them are willing to hire an attorney rather than just pay the assessments they owe. But sometimes they don't. And when they are pro se, meaning they're representing themselves, that's when we end up needing the court to require them to kind of clean up their responses so that we can tell what the heck they're even talking about. That happens pretty frequently, and it can increase your overall expense and the time that it takes for us to get through that foreclosure action. So just be aware of that. Again, there's almost no defenses to this. I mentioned this Abbey Park versus Bowen case and Ocean Trail versus Mead. These are cases that basically said the obligation to pay assessments is conditioned only on title ownership of the property and a proper budgeting process. Now, there are defenses, the estoppel and waiver arguments. The association gave a dollar figure, even if it was inadvertently, meaning the manager forgot to click the little button that says shut off access to the ledger. The owner got a ledger. They actually paid the amount that's listed in that ledger. That's the reliance aspect that's required for estoppel and waiver to kick in. Okay. If they paid that figure that was listed in the ledger, you're done. If the management firm or the association provided an estoppel certificate and didn't find out what was owed for fees and costs, for example, you're working with us under our collection retainer program and you're not being billed the fees and costs as we go, we're deferring all of that until that matter gets closed out. You have no idea what's owed unless you're looking on our website where we provide that information at any time. Okay, if you haven't checked the website in the last 3 months, you have no idea what fees and costs are owed. You're not going to include them in the estoppel certificate, and they're going to be wiped out if the owner closes in reliance on that estoppel certificate. This is usually, the estoppel is something that's requested in connection with a sale of the property, a mortgage of the property, etc. Basically, a title closing process. Again, we talked about the statute of limitations. That could cause a problem as well. And again, there's risk in not knowing what any individual judge is going to say that 5-year period. When does it start? So you don't want to ever come up against that 1 year or 5-year statute of limitations as applicable. The foreclosure action, we go to summary judgment. If there's no dispute as to the facts, basically the owner admitted they didn't pay, they just wanted a payment plan. That's not a defense, and there's no basis for them to argue that they have a defense. So summary judgment, hopefully in that instance, would be granted. If it's denied because there was evidence that contradicts the association's allegations, then the case might be set for trial. Understand, this is not a jury trial. It's purely a non-jury trial, meaning you still put on the same evidence. You still have to go to trial, but it's just in front of the judge, and the judge makes the final decision rather than a jury hearing all this and making a decision. A final judgment is basically the document you're looking for in this foreclosure action. It's going to say what's owed by the owner. It's going to say when they have to pay it to avoid a foreclosure sale. That sale date should be set within the judgment itself. And it basically says the owner has until the sale date to redeem the property by paying the clerk or paying the association the dollar figure that was owed pursuant to the judgment plus statutory post-judgment interest. The foreclosure sale is basically an auction. Think eBay for homes. That's literally what it is. It's usually going to be held online. In Central Florida, in a lot of counties, it's actually held at the courthouse still. That was the way that it was held across the board years ago, but now there's a Real Foreclose website that hosts most of these foreclosure sales. The property is basically just sold to the highest bidder. Winning bidder deposits at least 5% of the winning bid amount before the sale. If you haven't submitted that 5%, you can't bid up to and including any amount that exceeds what you've bid. So basically, I'm sorry, let me rephrase that. You cannot bid any more than what you've deposited. Meaning, if you haven't deposited that 5%, you're not bidding at all. If you do deposit that money, you win. You are the successful bidder as a non-association, and you end up taking the maximum winning bid. You have until noon the next day to come and deliver all of the funds. If that delivery happens and that third party ends up purchasing the property, congratulations, because that's the goal of the foreclosure sale. It's not for the association to end up with the property. It's for the association to be paid by virtue of the owner not paying and the association foreclosing. So that third party sale is fantastic because the clerk of court will then send the money to your attorney. You get paid in full. You get all your money. And that owner who couldn't afford to live in the property no longer owns the property. The alternative outcome of a foreclosure sale is that the association gets to bid up to and including the amount of its judgment, plus statutory interest. Okay, if you bid only up to those amounts, you don't have to come out of pocket and come up with that 5%. You don't have to come up with the additional funds the day after. The judgment just gets reduced, and the amounts that are owed to the association get reduced by the amount that the association bid. The minimum bid is going to be $100. And in a lot of cases, if no one else is interested in buying this, perhaps because there's a mortgage against the property and they know that that lender can wipe out the association, okay, great. The association ends up with the property. Then you can reach out to attorneys like me and our firm that'll give you guidance on how to rent it out, sell it without risking that you're going to get kicked in the teeth by the lender if they eventually foreclose. So these are all things that we deal with on a daily basis, but you might not. And so that's why you reach out when you end up with this property. It's not the labor of your attorney shouldn't end with, well, this is your property now, good luck. It should end with, this is your property now. Make sure to insure this property because you own it now. And let us know if you'd like some guidance on what your available options are to deal with the property that you now own. Don't just let it sit until the lender forecloses. That's giving away free money. Okay, let's figure out a way that the association still gets that money back that it was owed, or at least as much of it as possible. Now, finally, a certificate of title is a document that gets issued. The certificate of sale, the foreclosure sale itself, neither of those are what actually transfers ownership of this property after a foreclosure sale. That's the certificate of title. So you're going to have at least 10 days after that foreclosure sale is done before title ownership of the property transfers. And if someone stays in the property while that property is transferred, after the transfer happens, the purchaser can ask for what's called a writ of possession. Okay, this is basically the equivalent of an eviction without having to go through the eviction process. You've already gone through the foreclosure process. The person that's there doesn't have any right to be there any longer if they were named in the foreclosure suit. Okay, sheriff's going to come in and remove them, like an eviction, but only the last stage of the eviction process. Okay, what else is holding us up? Delays. I talked about service of process. The owner might be out of the country, which can severely delay and increase the cost of serving the owner. We might not be able to find them, or they might intentionally avoid the process server. Also, you might not know they're dead. And that does happen. I won't say frequently, but I would say 1 out of every 50 where, the reason they stop paying is because they stop living. That's usually a pretty good reason to stop paying, although it doesn't really help the association. The other thing that might hold you up is a qualifying offer. I didn't talk about this earlier, but there is a statute in 720. It doesn't exist for condos or co-ops, but it authorizes the owner, the defendant, to issue one qualifying offer. This is basically an affidavit that says, I'm going to pay this amount within 60 days, and if I don't, you can move forward with your foreclosure. From my perspective, I take that as an acknowledgement in affidavit form, meaning in written testimony, where the owner's agreeing they owe you the money. From my perspective, you move forward with your summary judgment right after that. Motion practice, discovery, these are all things that can hold us up. I talked about estoppel certificates. So this is basically a document that's produced by the association, says, here's what's owed on this property. If you want to close, you have to pay us this dollar figure. You have to deal with these issues and resolve these problems before you can close and have what's called clear title. Okay, it's essentially saying, hey, here's what we need in order to start fresh with either a new owner or not have a lender that's giving money and then eventually having the owner foreclose within the next X amount of time. It is something that needs to be provided within 10 business days after you receive the request, or you can't charge a fee for it. There was proposed legislation this year that would make things even worse, where you couldn't charge a fee at all. Fortunately, that was improved a little bit. It gets completed by the association or its agent. It's good for 30 days. If it's sent electronically, I don't know anyone that sends these by mail. And just understand, if you find that there's an error in this certificate or that something information changed, you might have an obligation to update it. You're not allowed to charge for that update, and that 30-day time frame or 35-day time frame restarts based on the date that you amended the certificate. Okay, these fees are a little outdated, but they're in the Florida Administrative Code. If you're curious about what they are, if you have a manager, they should know. If you need to know the specific dollar figures, just reach out to me and I'm happy to send you a quick email, but we don't have the time to go through them in detail today. We talked about the estoppel argument. This is basically, well, the association told me X and I relied on it and paid you, so you're out of luck. Okay, just make sure any of these issues that are listed in this slide, make sure that you're addressing them. When an owner asks for information, if the account's in collection, that attorney needs to be responding to the owner, not you. Moving forward to what I call unfair debt laws, and the reason for that is they are explicitly intended to benefit the owners and benefit debtors, meaning people that might or do owe money, and to hurt creditors. Now, the legislature, both Florida and federal, allege that this is not intended to hurt good creditors, meaning the ones that don't violate the law. But the reality is it's used as a tool by a lot of owners to basically shake down associations, shake down law firms, shake down management firms to try and reduce their debt in an invalid demand, because the bottom line is these laws that protect debtors, protect people that owe money from unfair collection practices, are used as a sword, not as a shield. The reason for that is because even if we prove that this person had no real basis to go after us and we did nothing wrong, even if a lawsuit's filed, we spend $50,000 to $100,000 defending it and we win, unless we can show that there was bad faith intended, which I've literally never seen, bad faith intended in the filing of the lawsuit and the demand being made by the owner, you don't get your fees and costs back. So you're spending all this money to prove that you did nothing wrong, and you're out that 50, 100 grand. So a lot of people will use this, again, as basically a means for a shakedown to get 5, 7 grand out of the association. Some associations, some law firms have basically taken the position, we're going to fight this as long as it takes, because if you want to spend a bunch of attorney's fees and costs to come after us, we're going to make you go toe-to-toe with us. Okay, that's a board decision. It's the decision of the individuals involved or the entities involved. And the reason I say that is because it protects these debt these debtors from debt collectors. The association is owed the debt. It's not a debt collector for most purposes. Okay, the Fair Debt Collection Practices Act is the federal one. Assessments are considered consumer debts subject to that law. They're also subject to the Florida equivalent, which we'll get into in a minute. But generally speaking, managers, management firms, and when I say managers, it really depends on what the major focus of the management firm's business is, whether they're considered a debt collector or not. It's the same with law firms. Okay, we don't have time to get into the details of that, but managers, management firms, attorneys, law firms, all might be subject to personal lawsuits, meaning being a personally named defendant in these types of cases if the owner decides to go after you. Same thing applies to the Florida equivalent. Now understand, the federal version pertains to debt collectors. The state version pertains to anyone collecting a debt. And I'd like to go a little more in depth on this. We just don't have the time because I have about 7 minutes left and I still need to get into mortgage foreclosure and bankruptcy. But if you've got questions about how this impacts you, your association, feel free to reach out. And frankly, it might not be the worst idea, Jeff, to eventually have a class that's specific to this. I think that would be a good benefit for managers. So if you don't mind reminding me of that, sorry guys, sometimes I come up with these ideas right midstream. So Jeff, if you can remind me of that, maybe we can work on it on a later date.
Sounds good.
But the bottom line is these are laws that are intended allegedly to protect people that owe money, but really just end up hurting creditors. Now, there are some creditors that really do wrong, and that was the initial intent. I just think it's being abused by people that are taking advantage of it. Kind of like the Fair Housing Act and the Americans with Disabilities Act. It's well intended, but it's being used as a sword, and I don't like that. Moving forward, mortgage foreclosure issues. The lender sued. Now what the heck do we do? My recommendation, file an answer, have your attorney monitor that case, know what's going on so that you know what your options are, whether you should be proceeding with your own collection efforts or if you should just be kind of waiting for a foreclosure sale to happen. Because if you're not actually having an attorney participate in this process, you might have no idea what's going on, and you'll probably have to pay every time that you have a question as to what's going on. Versus if we're monitoring, I can speak for our firm, I can't speak for others, but if we're monitoring, you've got those notes in our system. All you got to do is pull them up online. Proceeding despite the existence of a mortgage foreclosure is not always the best option. I mentioned that the association might be partially wiped out. If a lender forecloses, you're generally only going to be owed none of your interest, late fees, attorney's fees, and costs, which is really what's important here. Your attorney's fees and costs get wiped out, except for collecting them from the owner who was already foreclosed. Guess what the likelihood of that person having the money to pay you is going to be? Okay, but so you might have the ability to collect some of your unpaid assessments. If a lender forecloses or the lender forecloses and there is a provision in your declaration that benefits third-party purchasers at lender foreclosure sales, you might be limited to collecting from that foreclosed owner or the foreclosure sale funds, the proceeds from the foreclosure sale itself. You might not be able to collect anything from that new owner. So that's something that you're going to want to run by your attorney if you're not sure what you're owed. And let's be real, you're not sure what you're owed because you probably didn't even know that you'd be wiped out if the lender forecloses. At least that's been my experience with a lot of directors in community associations. So I recommend you respond to the complaint, claim lien priority over any other lien holder other than the first lender if you've got that lien priority, because that's really where you need to assert that priority if you want to ever be able to assert it. Moving forward, lenders often delay foreclosures. I mean, I came out of law school in 2008. Guess how long mortgage foreclosures were taking to be completed at that time? That's what I was addressing for 2 years before I joined KBR. Some of these were taking 3 to 5 years or longer to complete. Some of them are being handled a lot quicker now, but just understand, that we had a hurricane hit, we had COVID hit. In all these instances, the lenders a lot of times will just place their cases completely on hold for 6 months to a year, and judges will allow it. So you might be sitting there saying, well, we don't want to move forward, but we're stuck because the lender's not moving forward. Okay, well, then it might be a good idea at that point to have the association foreclose and see what you can do with that property if you're not already paid in full, with the owner knowing they don't have to pay their lender because they're already in foreclosure. Even after severe lender delays, judges in mortgage foreclosure cases can consider an association's interest in the timely resolution, but the lender's not going to be obligated to pay the assessments before ownership transfers. There are rare circumstances where they're egregiously violating court orders that the association might be entitled to that. I haven't seen it actually done except for in the case law that created that ability to go after the lender for the assessments that are not being paid by the owner. It just doesn't really happen. We talked about that safe harbor. Statutorily, if the association is named in a lender's mortgage foreclosure or the lender accepts a deed in lieu of foreclosure, that lender is only going to owe a maximum, if anything, of 12 months of unpaid assessments or 1% of the original mortgage debt, whichever is less. And it's from the date of the title transfer, meaning the certificate of title being issued or the deed being signed, not just from the date of the sale. Third-party purchasers generally owe all the unpaid assessments unless the declaration protects them. I mentioned that earlier. And anyone that buys at a foreclosure sale, a mortgage foreclosure sale, doesn't owe any interest, late fees, attorney's fees, or costs that predate the sale. We mentioned that as well. If the declaration provides purchasers more protection than the statute, you need to talk to your attorney about what they owe, if anything. Safe harbor is also impacted by the association having owned the property before the transfer. In other words, you foreclosed, then the lender foreclosed. You might have some of your assessments become uncollectible because of the association owning it. That's another thing I would just suggest. Talk to your attorney about what that means for you in particular. Bankruptcy issues, we're going to blitz through just what they are in general. Chapter 7 is basically you're wiping out the personal responsibility, meaning the association's ability to get a money judgment against the owner. They still are going to not be able to wipe out your lien. This is usually going to last 6 to 12 months. It's a petition. We don't really do anything other than check into what's going on every few months. Chapter 13, this can take up to 3 to 5 years once the plan's approved. And it's basically going to be either the owner's going to avoid your lien, discharge personal liability, and leave your lien in place, or preferably pay the association in full over those 3 to 5 years. They can also do what's called stripping the lien if there's no equity after all superior liens are going to be paid in a 13 or a Chapter 11. Chapter 11 is basically a business reorganization. 13 is more for individuals. So I don't really have the time because it's 2:59 to get into a ton of detail about bankruptcies. Let me just go through and see if there's anything crucial other than obviously the automatic stay. And please, for the love of God, do not violate the automatic stay by trying to get the owner to pay you money or do something on their property while they're in bankruptcy. And I think, yeah, owners do often use the stay to defer foreclosure sales. So keep in mind, if the owner files a bankruptcy petition and submits a document to the court saying, hey, I filed a bankruptcy, that automatic stay will result in the clerk of court automatically canceling any foreclosure sale that has been set in your case. You can try and lift the stay, basically be allowed to move forward if there's a lack of adequate protection of the creditor's interest in the property, meaning the association isn't getting paid under the plan, or because the debtor has no equity in the property and the property isn't necessary for an effective reorganization, meaning this property is worthless to you. Okay, so there's a lot more that goes into every single thing that I just said, but we had an hour to go through all of it. Again, if you have any questions whatsoever, please feel welcome to reach out to me via email. And I mentioned my email. Another way that you can get some free tips here and there is follow me on LinkedIn. I post something literally every day. So if you'd like to follow me there, you've got my name up on the screen right now. Hopefully you can read it. That's how to find me there. So getting into the actual Q&A, Genevieve Mendoza, you said you can charge 1 late fee per installment. If we have the monthly maintenance plus 3 special assessments going on, does this mean we can charge 4 late fees, 1 per charge on the ledger? And the answer is yes, absolutely. That was an easy one. Are we required to offer payment agreements before sending to legal for collections? Absolutely not. However, if you can reach those agreements, You never have to spend the attorney's fees and costs to get to that point, except perhaps to have your attorney draft a payment plan form, which is something that I do for a lot of our clients, where if you want to enter that payment plan and have those concrete consequences, I'll draft a form for the association to use on an ongoing basis. And I hate to be blunt, but we do have some clients that hire us just to have stuff like that prepared. We just prepare forms for them. They don't come to us for some reason for ongoing legal guidance. It's just, well, we like your idea of these 5 policies that everyone should have. We like your idea of notice of late assessment forms being prepared by counsel. We like your idea of having a form for a payment plan. Can you prepare those for us? And we might reach out to you at a later date after it's done. I'm happy to do that. Not a problem whatsoever. But the bottom line is, no, you don't have to offer a payment plan agreement ever, before or after it's sent to counsel. I think it's a good idea if an owner reaches out to you to agree to a payment plan with concrete consequences, but it's not an obligation the association has. So thank you for that question, Genevieve.
Alan, before your next question, I just want to mention, everybody, I opened up the chat. The chat is where you can put technical questions about the evaluation or anything not attorney related for me. So the chat is open if you have any issues or questions about the evaluation and that process. Alan, back to you. Sorry for the interruption.
No, no worries. Thank you for that. Can an HOA recover attorney's fees from unit owners for monitoring a complaint for foreclosure from the lender, even if the account's in good standing, paid on time? That's a tricky question because you're not really incurring that expense in collection of unpaid assessments if the mortgage foreclosure monitoring, occurs before the delinquency. But I think that there is potentially the opportunity to do it that way. It just depends how and when it's billed. But that is one that you'd have to speak with your individual law firm or individual collection counsel. It's going to be up to them whether they're willing to include that charge in any collection fees or not. I will tell you that I strongly recommend against sending a demand that the owner pay that attorney's fee if you're not going ahead and collecting anything other than that fee. I think sending a demand that they pay that so that you can monitor something when it has nothing to do with actual collection is a mistake. So hopefully that answered the question. Joel, can terms be agreed to on a case-by-case basis? Can an agreement provide for acceleration on default, and can an owner waive defenses if the default and acceleration occurs? Is it okay to give terms to some but not all owners? So you can do a case-by-case basis. There's really no selective enforcement, which is what I think you're worried about when it comes to collection efforts. I would suggest that you consider what's going on with the property when you say case-by-case, not just, well, we like this guy and the other guy's a jerk, so we're going to give the guy we like better terms. It should be based on, okay, is there a mortgage foreclosure? Is there a risk of bankruptcy? Do we think that this owner is actually going to pay? Things of that nature that are concrete. Hey, this is what we're basing this on, because if someone else does say, well, why did you offer him these terms and not me? You want to have some kind of response. Can you accelerate on default? Yes, especially if your governing documents say you can, but they can agree to it if they choose to. There's very little that you can't put in this type of settlement agreement, including, by the way, if you've got an ongoing covenant violation, I usually will include those all in the same agreement. You either cure the violation and pay in full, or we foreclose. Can the owner waive defenses to the foreclosure action, I presume? The answer is absolutely yes, and that's included in all of my settlement agreements for collection matters. My buddy Toad, what if delinquent owner rents his unit to a tenant who is providing the owner in-kind services in lieu of rent? What obligation does the tenant have to the association under those circumstances? Excellent question. The delinquent owner renting their unit, paying in-kind services, the tenant only has the legal obligation to pay what they would have been paying the owner. So usually that's dollars. We're not talking about, well, they were repairing the owner's driveway, so they have to replace or repair an association driveway. You'd probably be out of luck with a rent demand there, but you'd still be able to send your normal demands and pursue a lot of the other things, like not allowing the owner to use, not allowing the tenant to use amenities, things of that nature. For example, if you've got a clubhouse and a pool, you can tell them they're not allowed to use that until this obligation is paid in full. So hopefully that answers the question. You know where to reach me if not.
And folks, there are a couple of attorney questions in the chat. Remember, the chat is only for me. I'm not an attorney. They're for technical questions about the evaluation or anything else. So, for example, Jay, you posted something in the chat. Please put that into the Q&A. Back to you, Alan.
Thank you. If a homeowner filed bankruptcy, does that mean that we can no longer enforce violations and levy a fine? Generally, during the bankruptcy, you'll want your attorney to get the relief from the bankruptcy court authorizing you to do that, or have the owner agree in advance that that won't be treated as a violation of the automatic stay. So the short answer is no, you can't just move it forward blindly, but you can ask for the lender, I'm sorry, the bankruptcy judge or the owner to simply agree that you're allowed to move forward. Emily, when an owner is delinquent, but they have renovations inside their unit, are you able to stop the renovations for continuing due to delinquency or no? No, not really. Unless your governing documents specifically say that you can deny an architectural application due to a delinquency, you don't have the right to do that. And even then, it would only be the ability to deny the application itself. It would not be the right to say, well, you're halfway done. Now you got to leave that pool unfinished because you haven't paid your assessments. That's not going to be an option. Joel, is it a breach of fiduciary obligation not to pursue collection of delinquent owners? I will unequivocally say that, in my opinion, yes, it is. Because you're basically making the entire association, meaning every other member, responsible for the unpaid assessments. That's why I say every community should have a policy in place that specifically says how and when you're going to move forward. Now, the next question by Steve, when should we be moving forward with that notice of late assessment? When should we begin the delinquent collection process? Should it be 30, 60, 90 days, or a dollar amount? My perspective is if you're more than one or two installments past due, or the time for 1 and 2 installments has passed and you have not paid, that should be good enough for the association to say, we're going to proceed with collection. You shouldn't be putting more than 2 months worth of debt on the association that the association needs in order to properly maintain and operate the community. Carlos, if we sue a resident for not making a repair and they lose, how do we go about collecting our legal fees and still force them to make the repair they refused to do that led to the lawsuit? That's covenant enforcement. We've got an entire class on it, and I suggest that you go ahead and take that class. But again, the way that I suggest handling that is the amendment that I mentioned right at the beginning of the class today, which is to make those fees and costs incurred in enforcement an actual obligation to the owner. How do you force them to make the repair? You don't just file a lawsuit saying they should have done it. You file a lawsuit getting an injunction forcing them to actually do it. So that's the answer to those 2 questions. How long is a 30-day letter good for? Karen, it's good for 30 days.
Is it okay to, sorry. I thought that was cute.
I don't know if there was more complications there, but it seemed to me.
I was thinking maybe it was a trick question.
I thought it might be, but I think I got it right. Jose, thank you. I appreciate it. Let's see. Joel, thank you again. Guillaume, how to deal with assessments shared between master and sub when the HOA collects both in one monthly assessment? The answer is don't do it that way, or make sure that one set of governing documents authorizes the one to collect for the other, and then the one is dispersing to the master. So it's usually going to be that the sub collects on behalf of the master and then pays up to the master.
Alan, let me ask you a quick question, joking aside with the 30-day thing. Maybe the person meant business days or 30 total days. Is there a difference?
It's 30 calendar days. However, if that last 30th day falls on a weekend or a holiday, you're going to go to the next business day before you can take the next step. So
got it.
Valid point. Appreciate that. Sure. So Guillaume, I think I answered that. If you have any questions, you know how to reach me as well. Feel free to email me. How do you handle an owner who doesn't pay monthly dues or special assessments until they're threatened with a lien on the condo? Threaten them with a lien on the condo. Done. And tell them, you're going to be responsible for the attorney's fees and costs that we incurred in going forward with this, period. Is marijuana use allowed? I'm sorry, Simone, this is a covenant enforcement issue, not a collection issue. You're welcome to reach out to me separate, but marijuana use is an issue that can be an issue in a community association, especially in a condo. It's something I've dealt with before, but it's not the subject today. So given the fact that we've got negative 1 minute left, I'm gonna can you review tax sales and the effects on the ownership transfer and lack of title? A tax deed sale wipes out ownership, wipes out all the liens except for the taxes. That's pretty much it. So it doesn't matter. The person that took title at that tax deed sale now owns the property. They don't owe anything that was owed on the property before. Every lien, except for maybe some municipal liens, that's going to be wiped out.
So, Alan, last question is Karen's at the end, and I know you have to get running.
Thought a 30-day letter was a requirement before accelerating to the next letter, intent to foreclose. Could send action, sent letter 90 days ago. Yeah, the notice of late assessment is good for 30 days. Once that expires, you can send your notice of intent to lien. That's good for 45 days. Once that expires, you file your lien, and then you can send your notice of intent to foreclose. Once that expires, that one's good for 45 days. Then you can file your foreclosure action. So if I didn't answer your question, I'm not trying to be flippant here. Please feel free to email me or give me a call at the office, and maybe I can walk you through if there's something I'm not understanding in the question, the way it's being worded. So thank you, everyone. Again, feel free to email me, find me on LinkedIn, and hope to hear from you soon. If you need an attorney, I'm one of those. So I'd be happy to hear from you about that as well. Jeff, I'll leave it to you, and sorry for going a little over. Thank you all for your time, and I'm going to jump off here unless, Jeff, you need me for anything.